Welcome to Two Titles, One Land, a primer on the paradigm shift in Canadian property rights and Aboriginal title. This video explores the complex collision between the settler system and the Indigenous system of land ownership in Canada. The core conflict stems from two distinct legal systems operating on the same physical space. The settler system is based on private property and provincial statutes, while the Indigenous system is based on pre-sovereignty occupation and constitutional law. The collision point is where 95% of British Columbia's unceded territory creates legal and economic crises. This chart illustrates the key differences between fee simple, or private property, and Aboriginal title. Note the contrasting origins, ownership, alienability, limits on use, and legal status of the two systems. The 2014 Cowichan Nation decision fundamentally changed the landscape. The Supreme Court rejected the, quote, postage stamp view of Aboriginal rights, declaring Aboriginal title territorial, conferring the exclusive right to decide how the land is used. The key question today is whether Aboriginal title can exist on private land. This illustrates the two layers: fee simple, the visible private property, and Aboriginal title, the hidden constitutional layer beneath, leading to a collision. Recent court decisions have diverged, creating conflicting legal realities. British Columbia's court ruled that Aboriginal title and fee simple coexist, with Aboriginal title being the senior interest. New Brunswick's court, however, ruled they cannot, suggesting compensation as the remedy. The Supreme Court of Canada must resolve this contradiction. The 2025 Cowichan decision in British Columbia declared Aboriginal title over private lands on Lulu Island. The court ruled that Crown grants do not extinguish Aboriginal title, and statutory protections fail to apply. This left private owners in a state of legal limbo. The market impact of the Cowichan decision stems from constitutional asymmetry. Aboriginal title, protected by the Constitution Act 1982, is immune to extinction. Private property, based on provincial statutes, lacks this constitutional protection. When the two collide, the Constitution prevails. The economic implications, or market chill, include financing collapses, redefined due diligence, transaction paralysis, and slowed investment capital in resource development due to title uncertainty. Beyond the courts, legislation is shifting the landscape. British Columbia's DRIPA adoption gives the UN Declaration on the Rights of Indigenous Peoples legal effect, requiring free, prior, and informed consent for projects affecting Indigenous lands. The courts are ill-equipped to solve this crisis. A spectrum of solutions exists. Litigation is long and uncertain. Damages and compensation, the Wolastoqey approach, shields property owners but requires Crown payment. Collaborative coexistence through negotiated agreements offers the most viable path to certainty and economic partnership. Negotiated agreements are already creating coexistence. The 2024 Haida Gwaii Agreement recognizes Aboriginal title while explicitly protecting private property. Similarly, the 2023 Blueberry River Agreement provides predictability for industrial development alongside protecting treaty rights and creating protected areas. The recognition of Aboriginal title over private land has shattered the illusion of absolute ownership, bringing a hidden constitutional layer to the surface. While court cases cause short-term market uncertainty, they compel the Crown to move away from litigation toward modern, negotiated treaties that balance Indigenous sovereignty with market certainty.